There are certain things in life that feel sacred. For some people, it is a morning cup of coffee before the rest of the world wakes up. For others, it is a long walk at sunset, the kind where your mind finally goes quiet. But for the narrator of this story, a man who had spent 15 years working brutal hours, saving carefully, and sacrificing more weekends than he could count, the sacred thing was simple. It was Sunday, it was his backyard, and it was his grill. He had not stumbled into this property by accident. He had hunted for it, spent 2 full years searching for a home that sat on genuine private land, outside city limits, far enough from subdivisions and HOA-governed communities that no board of strangers could ever tell him what color to paint his shutters or how tall his grass could grow. When he finally found it, a sprawling estate tucked behind a long gravel driveway, surrounded by mature oak trees, with no HOA, no shared walls, and no governing body of any kind. He felt something close to relief that he had never felt before. He signed the papers, moved in, and exhaled for what felt like the first time in years. The property was entirely his. The deed said so. The county records said so. Every survey, every boundary marker, every legal document attached to that land confirmed what he already knew in his bones. This was private ground, and he was the sole owner. His nearest neighbor was roughly 120 yards away, separated by a stretch of mature hedgerow and a gravel access road that ran between their properties. Under normal circumstances, 120 yards is more than enough distance for 2 people to live completely separate lives without ever interfering with each other. Under normal circumstances, his neighbor, a woman the internet would have recognized immediately if they had seen the way she operated, had moved in about 8 months before he did. She had purchased the house next door, which sat inside a small, loosely organized community with a voluntary neighborhood association. The key word there was voluntary. It carried no legal authority. It had no enforcement power. It could send strongly worded letters and hold bake sales, but it could not fine anyone, foreclose on anyone, or compel anyone to do anything. And critically, the man's property was not part of it, not adjacent to it in any legal sense, not subject to any of its guidelines, suggestions, or preferences. His land was simply, cleanly, and entirely outside its reach. She did not see it that way. The first Sunday he fired up his grill, the smell of charcoal drifted through the afternoon air the way it does in every neighborhood across the country every single weekend of every single summer. He had marinated chicken thighs since the previous night. He had cold drinks in a cooler. He had a playlist going through a Bluetooth speaker at a volume that would not have disturbed anyone in the same room, let alone 120 yards away. It was, by any reasonable measure, a completely unremarkable afternoon. The police cruiser rolled up his gravel driveway 45 minutes later. The officer was polite, almost apologetic even. He explained that a neighbor had called in a complaint about smoke and described it as a potential fire hazard and, in the caller's own words, a public health emergency. The officer looked around at the peaceful backyard, at the modest amount of smoke rising from a standard charcoal grill, at the man standing there holding a pair of tongs with an expression of complete disbelief, and he issued no citation. There was nothing to cite. He shook the man's hand, told him to enjoy his afternoon, and left. The man stood there for a long moment after the cruiser disappeared back down the driveway. Then he put the tongs down, pulled out his phone, and opened a new note. He typed the date. He typed the time. He typed a brief description of what had happened. Then he went back to his grill because the chicken was not going to cook itself. He thought it was a one-time thing. A misunderstanding, maybe. A new neighbor who didn't yet understand where the property lines were, who perhaps genuinely believed she had some authority over the land next door. He was, in retrospect, extraordinarily generous in that initial assumption. The following Sunday, she called again. Same complaint, different officer, same outcome, no citation, no violation, nothing to act on. The officer this time seemed slightly less apologetic and slightly more aware of what he had driven out to. He told the man that if this happened again, he was free to file a counter-report documenting the false call. The man thanked him, updated his notes, and flipped his burgers. By the 4th Sunday, the responding officers were beginning to recognize the address. By the 6th, one of them actually stopped to chat for a few minutes, curious about what exactly was happening in the broader picture. The man explained everything. The property lines, the lack of HOA affiliation, the documented calls, and the officer nodded slowly. The way people nod when a situation that initially seemed strange suddenly makes complete and total sense. By week 12, he had started keeping a dedicated log. Not just a phone note anymore, a proper document, stored both locally and in a cloud backup, with timestamps, officer badge numbers where he could obtain them, a brief description of each interaction, weather conditions, photographs of the grill setup, and audio recordings made on his phone from the moment he saw the cruiser coming up the driveway. He had also done something that would prove to be enormously important later. He had installed 4 security cameras covering his backyard, his driveway, and the stretch of gravel road between his property and hers. The calls kept coming, every single Sunday, without exception, for months. Rain or shine, cold or warm, whether he was grilling a full spread or simply lighting the thing to make a point, the call came. Sometimes it came early, before he had even finished setting up. Sometimes it came late, as if she had been watching and waiting for the exact right moment. But it always came. 52 Sundays in a row. 52 documented police responses. 52 entries in a log that was growing into something that looked less like a personal diary and more like a legal exhibit. He had, by this point, consulted with an attorney. Not yet retained one. Just consulted, in the way that people do when they want to understand their options before committing to a path. The attorney had listened carefully, reviewed the documentation the man brought with him, and then said something that the man had already begun to suspect but needed to hear from someone with a law degree. What was happening to him had a name. It was called harassment. It was potentially actionable. And the log he had been keeping was, in the attorney's words, exactly the kind of evidence that made cases like this very straightforward. The man drove home that afternoon thinking carefully. He was not an angry person by nature. He had not moved out to this private land because he wanted conflict. He had moved there specifically to avoid it. But there is a difference between avoiding conflict and allowing yourself to be endlessly targeted by someone who has decided, for reasons that exist only inside her own head, that your legal, peaceful, fully documented Sunday afternoon activities are somehow subject to her approval. On the 52nd Sunday, he grilled as usual. The call came as usual. The officer arrived as usual. But this time, when the officer left, the man did not simply update his log and go back to his food. He pulled up his attorney's contact, typed out a message with 3 words, "I'm ready now," and hit send. There is a particular kind of confidence that comes from believing, for an extended period of time, that your actions have no consequences. It is not the same as arrogance, though it often looks like it from the outside. It is something quieter and more dangerous, a settled, bone-deep assumption that the rules apply to everyone around you, but somehow curve away before they ever reach your door. That was the world Karen had been living in for 52 Sundays. A world where she could pick up the phone, dial emergency services, make a false claim, and watch a police cruiser roll up her neighbor's driveway, week after week, month after month, with no pushback, no accountability, and no end in sight. That world was about to end. The attorney the man retained was not a dramatic person. She did not make speeches. She did not send threatening letters designed to intimidate. She was methodical, precise, and extraordinarily good at building cases out of documentation, which meant that the log the man had kept for over a year was, in her words, one of the cleanest evidentiary records she had seen walk through her office door. 52 entries, 52 dates, timestamps, officer interactions, photographs, audio recordings, and security camera footage covering every single incident from week 3 onward. It was not a collection of grievances. It was a case file. The legal theory was not complicated. Placing repeated false reports to emergency services is a crime in virtually every jurisdiction in the country, beyond the criminal dimension. Doing so with the clear intention of harassing a specific individual, targeting them on a documented schedule, making false claims about a public health emergency that any responding officer could immediately verify did not exist, opened the door to civil liability as well. The attorney filed on both tracks simultaneously. A formal harassment complaint with the county sheriff's office, supported by the full documentation package, and a civil suit for intentional infliction of emotional distress and abuse of the emergency services system. Karen was served on a Tuesday morning. The man was not there to see it, but he heard about it from a mutual acquaintance later that week, and the description he received was something he replayed in his mind with quiet satisfaction for a long time afterward. Apparently, she had not expected it. Apparently, she had stood in her doorway holding the papers with an expression that suggested she had, until that exact moment, genuinely believed that none of this was ever going to come back to her. She hired an attorney of her own. That attorney's first move was to contact the man's attorney and suggest that perhaps this was all a misunderstanding, that his client had simply been concerned about fire safety, that she had not intended to cause any harm, and that surely the parties could resolve this privately without the need for court involvement. The man's attorney sent back a response that was 4 sentences long and contained no flexibility whatsoever. There would be no private resolution. There would be no quiet settlement that allowed Karen to walk away without a public record of what she had done. The case was moving forward. What happened next was the moment the entire situation shifted from a local dispute into something that felt almost cinematic in its irony. Karen, apparently advised poorly or simply incapable of stopping herself, made a decision during the weeks leading up to the hearing that was so spectacularly counterproductive that even the man's attorney, a person who prided herself on remaining professionally neutral, called him to describe it with something approaching disbelief in her voice. Karen had gone to the Voluntary Neighborhood Association, the one the man was not a member of, had never been a member of, had no legal connection to whatsoever, and had presented his case as an example of a neighbor refusing to comply with community standards. She had shown them his address. She had described his Sunday grilling as a violation of what she called the spirit of the neighborhood. She had asked the association to send him a formal letter of censure. The association had done it. They had sent the letter. That letter, addressed to a man who had no membership in the association, no obligation to it, and no legal relationship with it of any kind, arrived in his mailbox on a Thursday. He photographed it immediately. His attorney received the image within minutes. And both of them understood at once what it represented, because Karen had now done something that crossed a critical legal threshold. She had coordinated with a third party to target the man based on false premises, extending the harassment campaign beyond her individual phone calls into a broader organized effort. It was, in the attorney's assessment, the single most helpful thing Karen could have done for their case. The hearing date arrived on a gray morning in early spring. The courtroom was not packed. This was not the kind of case that draws a crowd, but it was not empty either. A few people who had become aware of the situation through the neighborhood grapevine had shown up, and they sat quietly in the gallery as both parties took their seats. The man's attorney presented the case in the order the documentation demanded. She began with the first call, the date, the officer's response, the absence of any violation. She moved forward through the weeks methodically, building the timeline entry by entry, letting the sheer repetition of it do most of the work. 52 incidents, each one documented, each one resulting in a police response that found nothing wrong, each one logged with enough specificity that there was no room for ambiguity about what had happened and when. Then came the security camera footage, clips from dozens of Sundays, the man in his backyard doing nothing more than grilling, and then the cruiser arriving, and then leaving without incident. Played consecutively, the footage had an effect that no argument could have replicated. It made the pattern visible in a way that was impossible to dismiss or reframe. This was not a concerned neighbor occasionally worried about fire safety. This was a systematic, deliberate, recurring campaign targeted at one person on one specific day each week for over a year. Then came the letter from the neighborhood association, presented not as a side note, but as a pivotal exhibit, evidence that the harassment had not remained individual, but had been deliberately extended through the involvement of a third party operating on false information Karen herself had supplied. Karen's attorney argued that his client had genuinely believed there was a fire risk. He argued that she had acted out of community concern. He argued that the association letter was independent of his client's actions and could not be attributed to her. The judge listened to all of it with the particular expression that experienced judges develop, the one that reveals nothing while processing. The ruling came without a long wait. The judge found sufficient grounds to proceed on the harassment claim. Karen was ordered to pay a civil fine for the documented abuse of the emergency services system, not a life-altering sum. The man walked out of that courtroom into the gray spring morning and stood in the parking lot for a moment, breathing the outside air. His attorney shook his hand, and said something practical about next steps, about ensuring the order was properly filed, about monitoring compliance. He nodded at all of it, but what he was actually thinking about in that particular moment was that the following Sunday was 4 days away, and he already knew what he was going to make. He went home. He checked his cameras, all 4 of them, still running, still recording. He opened his documentation log, added a final entry with that morning's date and a single word, resolved. And on Sunday, he lit the grill. The smoke rose slow and easy into the afternoon sky, the way it always had. The chicken was perfect. The afternoon was quiet. No cruiser came up the driveway. No phone rang in a house 120 yards away, or if it did, no one was calling 911 from it. The backyard was his. It had always been his. And now, finally, everyone knew it. If you made it this far, you already know what to do. Hit that like button, subscribe, and drop a comment below. What would you have done differently? Because something tells me this channel is just getting started.